Welcome back to the channel. Today, we are examining one of the most foundational doctrines in the entire corpus of criminal law, Mens Rea, the guilty mind. Whether you are a law student, a practicing barrister, a legal academic, or simply a citizen who desires to understand how criminal justice operates, this video is for you. We will be drawing substantially from authoritative decisions of the Supreme Court of Nigeria, as well as landmark common law precedents, to illuminate this doctrine in a manner that is both academically rigorous and practically accessible. Let us proceed. The Latin maxim, Actus non facit reum nisi mens sit rea, translates to, an act does not make a person guilty unless the mind is also guilty. This ancient legal principle forms the bedrock of criminal liability in all common law jurisdictions, including Nigeria. In simple terms, mens rea is the mental element of a crime. It is the criminal intention, the guilty knowledge, or the blameworthy state of mind that must accompany the actus reus, the physical act, before criminal liability can properly attach to an accused person. The Supreme Court of Nigeria gave an authoritative and comprehensive articulation of this doctrine in the case of Yelli against State, decided on the 13th of May 2022. Her Lordship, Justice Augie, delivering the leading judgment of the court, stated unequivocally, a crime consists of both mental and physical elements. Mens rea, a person's awareness that his or her conduct is criminal, is the mental element. And actus reus, the act itself, is the physical element. The court further held that mens rea means guilty mind, and connotes that an act alone could not create criminal liability unless it is accompanied by a guilty state of mind. In other words, mens rea is a criminal intention or the knowledge that an act is wrong. This same principle was echoed identically in Olaiya against the state, also decided by the Supreme Court, and again in Olaiya against the state, and Lawan against Federal Republic of Nigeria, demonstrating that this is settled, consistent jurisprudence at the apex court level. Criminal liability, properly understood, is a compound concept. It demands the coexistence of two elements, the actus reus and the mens rea. Neither element alone ordinarily suffices. In Lawan against Federal Republic of Nigeria, Justice Ogunwumiju of the Supreme Court stated with precision that mens rea entails that there must be a meeting of the mind and the act of the offender for the offense to be complete. The court further noted that since it is not humanly possible to ascertain with mathematical accuracy the devices of a man's heart, intention may be discerned from the overt actions of the offender and from circumstantial evidence. This principle was powerfully reinforced in Afolabi against the state, where the Supreme Court held that every person is presumed to intend the natural and probable consequences of his acts. Intention in law, the court explained, is the willingness to bring about something planned or foreseen, the state of being set to do something. Where a man aims a firearm at the chest of another and discharges it, the natural and irresistible inference is that he intended to cause either death or grievous bodily harm. Because mens rea is an internal mental state, it cannot be observed directly. Courts are therefore compelled to infer it from external evidence, from what the accused did, how he did it, what instrument he employed, and upon which part of the body the blow or act was directed. In Afolabi against the state, Justice Okoro of the Supreme Court laid down the following propositions. Intention, not being tangible, can be inferred from the instrument used to commit the crime, the force applied, and the particular part of the body targeted. He stated, when the appellant aimed his gun at the chest of the deceased and shot him, he did not intend to keep him alive. At least he intended to cause him grievous bodily harm. Similarly, in Olaiya against the state, the Supreme Court held that intent can be proved either positively where there is direct evidence of the accused's declared intention or inferentially from the overt acts of the accused. A person has mens rea for murder if, when he performs the act which kills, he knows that it is highly probable that death or grievous bodily harm will result. In Yelli against state, the court examined the accused who had climbed over a wall in the dead of night and struck a sleeping man on the head with a stick. The court held that the act of scaling a wall under cover of darkness and deliberately targeting the head of a sleeping and defenseless victim admitted of only one conclusion: a clear and deliberate intention to cause death. It is important to appreciate that mens rea is not monolithic. It exists on a spectrum. Nigerian statutory criminal law, drawing from both the criminal code applicable in the South and the penal code applicable in the North, recognizes varying degrees of culpable mental states. At the apex sits intention, the deliberate and purposeful desire to bring about a particular consequence. Below that sits knowledge, the awareness that a particular consequence is a probable result of one's act. Then there is recklessness, the conscious disregard of a known and unjustifiable risk. In Olaiya against the state, the Supreme Court noted that there are only two states of mind which constitute mens rea in the context of murder: intention and recklessness. The court observed that once intention to kill is satisfactorily proved beyond reasonable doubt, it becomes unnecessary to establish that the accused also knew death was the probable consequence. The two are alternative, not cumulative requirements. This graduated approach is critical. It explains, for example, how the offense of culpable homicide, punishable with death under Section 221 of the Penal Code, differs from culpable homicide, not punishable with death, the distinction lying principally in the degree and quality of the accused's mental state at the time of the act. Now let us turn briefly to two English authorities that serve as cautionary counterpoints in the discourse on mens rea. The first is R against Pittwood, 1902. Mr. Pittwood was employed as a gatekeeper on a railway crossing. He negligently left the gate open when a train was approaching. A man was killed. Pittwood was convicted of manslaughter. The court held that where a person assumes a duty of care by contract, even a private employment contract, and negligently breaches that duty causing death, criminal liability may attach. The lesson here is that in certain offenses, particularly those involving criminal negligence, the required mental element is not intention but the gross departure from the standard of care that a reasonable person would exercise. The second is the more controversial R against Larsonneur, 1933. Miss Larsonneur, a French national, was ordered to leave the United Kingdom. She traveled to Ireland, was deported back to England by Irish authorities against her will, and was immediately arrested and convicted of being found in the United Kingdom without leave. She had no intention to return and no control over her deportation. The court nonetheless convicted her. This case is widely criticized by legal scholars as an instance of liability without genuine mens rea, a strict liability offense that many argue produced an unjust outcome. It serves as a stark reminder of why the mens rea requirement exists, to ensure that the law punishes moral culpability, not mere misfortune. Nigerian courts have, by and large, maintained a robust commitment to the mens rea requirement, particularly in capital offenses, a point we will develop shortly. The requirement of mens rea assumes its greatest practical urgency in capital offenses, where the state seeks to take the life of the accused. In Ononuju against the state, 2014, a case arising from a police shooting at a checkpoint, the Supreme Court, in a majority decision, allowed the appeal of a police officer convicted of murder, having found material contradictions in the prosecution's evidence. The court reiterated that the prosecution bears the burden of proving not only the Actus Reus, the act that caused death, but also the mens rea, the intention or knowledge with which that act was committed. The court held, per Justice Alagoa, that the mental aspect or mens rea is very important in establishing the guilt or innocence of an accused person in a charge of murder, as in other offenses, except offenses of strict liability where the mens rea is dispensed with. In Ejinima against the state, a father killed his 3 children, claiming he did so because he believed his wife had poisoned him and he did not want his children to suffer after his death. The Supreme Court examined both the defense of insanity and that of insane delusion under Section 28 of the Criminal Code. Justice Reus made the striking observation that the mind of anyone suffering from insanity has no room for mens rea. Action or behavior induced by insanity is carried out on a blank mind without any thought whatsoever. The court dismissed the appeal, finding that the evidence did not support the defense, but the dictum powerfully illustrates how mens rea and mental capacity are inextricably linked. It is instructive to note that mens rea does not operate uniformly across all offenses. in the context of armed robbery under the Robbery and Firearms Special Provisions Act, the Supreme Court, in both Adekoya against the state and Olaiya against the state, held that armed robbery and conspiracy to commit armed robbery are not offenses for which the traditional mens rea of evil intention must be separately established, because the specific ingredients of the offense are exhaustively prescribed by statute. The court held in Adekoya against the state that while the presumption of mens rea exists in every offense, that presumption is subject to displacement by the words of the statute creating the offense. What matters is the use or display of an offensive weapon in the course of robbing a victim, not necessarily a separately established guilty intent. In Olaiya against the state, Justice Nuiz confirmed that intention or malice no longer governs criminal responsibility in armed robbery, as they are common law concepts now superseded by statutory definitions. What the prosecution must prove is the prescribed statutory ingredients that a robbery occurred, that the accused was armed or in the company of armed persons, and that the victim was dispossessed of property through force or fear. This is a critical distinction. It does not abolish mens rea, it simply establishes that in statute-based offenses, the legislature defines what the required mental element is, and courts must give effect to that statutory definition. Why does all of this matter? Why do we insist on proof of mens rea before convicting an accused person? The answer lies in the fundamental principle of justice upon which criminal law is constructed. To punish a person for an act that was accidental, compelled, or performed without any awareness of its wrongfulness is not justice. It is oppression dressed in legal costume. In Oghor against the state, the Court of Appeal, Port Harcourt Division, allowed the appeal of a university student convicted of the murder of a fellow student, finding that the learned trial judge had erred in excluding the defense of accidental killing under Section 24 of the Criminal Code. The court held that an event which occurs by accident, being an event totally unexpected by the doer and not reasonably to be expected by any reasonable person, does not engage criminal liability because the necessary mens rea is absent. Justice Culpable stated eloquently, "A judgment sending a man to the gallows must be seen to be the product of logical thinking based upon admissible evidence, in which the facts leading to his conviction are clearly found and the legal deductions therefrom carefully made." This is why mens rea is not a technicality. It is the moral foundation of criminal justice. It is what separates the deliberate wrongdoer from the unfortunate victim of circumstance. In summary, mens rea is the indispensable companion of Actus Reus in the constitution of criminal liability. It may manifest as intention, knowledge, or recklessness, depending on the offense in question. It must ordinarily be proved by the prosecution beyond reasonable doubt, whether through direct evidence of declared intent or by legitimate inference from the accused's overt conduct. As the Supreme Court of Nigeria has consistently held from Yelli against state to Lawan against Federal Republic of Nigeria, from Afolabi against state to Ononuju against state, the guilty mind is not a peripheral consideration. It is the very soul of criminal responsibility. If you found this exposition instructive, please like, share, and subscribe. Leave your questions or legal observations in the comments section below. For practitioners and students seeking deeper engagement with these authorities, the full citations are provided in the description. Until the next edition, keep thinking critically, keep practicing diligently, and keep the law rigorous.